carry about things, the bigger companies. So if Charter is, I don't know about it. But I'm glad that he's at least zooming in.
Here's the next little section with that bundle that I gave you.
Thank you. I'm gonna be looking at the storm as usual. Kind of showing this morning. Hello. Hello.
There's trouble.
That's right.
I've been 5 years and taking photographs. Yeah. That's like my life. When I'm not chasing my kids around. Yeah. Not too much for these things. That's right. Starting fires and starting. Kids around. That sounds good. Yeah. Everyone plays a role. That's right.
This is the same stack.
Yes.
Some people put them out, some people stuff them. I like to be on the fence that if I can, not those. We got. I think that was maybe one of that.
I just would presume all these stay wireless invoices that come.
So I
grant.
get shot across with one.
The total 62,000, I presume knows where. Someone looks at it and knows
Yeah.
that they're
Well,
correcting.
part of the upgrades that they're doing on your meters.
Cool. 5:15.
I don't know. I saw that as well.
I don't know anything about it. Is it like soccer with sticks?
It's like, that's, yeah, this is down. It's like basketball, soccer, hockey, football.
Okay, they do it all. They can't hit each other, though. They can hit each other. They can do. Yeah.
It's hockey is the funnest to go watch. I think
Kids, sort of black, and the kids open. No kidding.
I saw that as well. It's the first I've seen of it.
See, there's a screen.
So Bill, do you think technology is gonna work today?
Working right now.
Okay.
Well, that's what happened to my
There's a lot of aspects. I wish they had had.
projector.
They would have right here when I was in school. My boys do it on baseball, so the season's confused. I've had Jeff. I'm so glad I leave.
I'd rather be honest with you, all now. Than watch baseball.
Yeah. They do preseason. And so we used to have preseason, rain all over. And they were funded, it was doing like now, so they were social, that was a lot. Horrible. And so, but going to a hockey game, how that on the other hand, we are so excited.
Why would you?
It's just like, they get so into it and it's like, just the atmosphere is pretty good. Yeah.
So go with a couple of guys to those once in a while. Yeah. And then.
Oh my gosh.
We went to Boise. Okay, it's time to leave. Can't be in my head.
If you ever get the opportunity to go to a hockey game in Phoenix, It is wild, like it is.
TV's going on as much. Well, hockey live.
Yes. Yeah.
Dude, especially if you can get closer to the glass. Just the pucks flying, dudes are pushing, turning the wall. And they get this fight, and now gets into it. And
The crowds.
people sometimes think, yeah. I'm like, yeah, they are.
Maybe that's it, when you're watching that ski land, you're doing all that.
Oh, man. Makes they give.
Yeah, I, in college, I did an internship where I got to run an auction at the Spokane Chiefs. One of their just. I would walk down. And see some of the sections, I'm just like. They don't know what they're.
Yeah, it's a fairly simple sport.
But I mean, like, you know, as far as like what the premise is, like, there, obviously there's got to be a line rules, there's still. All you started to know about it now, as you're trying to hit a puck into the goal, that's it. You know, I don't.
While skating.
Yeah. See, people are like, oh, that's, and there are seats everywhere, like, NBC's all, you go to a hockey game in the arena, the big arena. Yelling and cheering and the crowd doing games, like the whole crowd would do games all the time. Had a captain that had box seats, he did season box seats. And I loved it when he couldn't go, because he'd give me his ticket, give me his thing, and, yep, I'm going.
No, it'd be fun. I like take the family to a hockey game. I know my boys would eat it up.
Yeah.
Shoot over the boys. Yeah, maybe.
I enjoy life. We still have to know what's called a family.
Yeah.
Go listen to all that.
Wish that coach was at all, so you can like, Jim was gonna walk through play. She can't see, she can't get on the floor right now. Sure, a month, can't help but think it's. I just know where basketball is.
Oregon State League, that Oregon State League, stuff sure has fun, doesn't it?
Had the hiders and stuff. Well, I remember that for the first. It's pretty amazing.
Right.
I feel that.
Hoping we don't die as soon as we parole or retire.
Oh, yeah.
It was like, I retired in 2004, I'm doing good.
All right, good morning, everybody. Welcome to County Court. It is Wednesday, April 17th at 10 a.m. If you'll please stand and join me for pledge allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
It's not a fun one.
Yeah, I know, it just kicked off.
Oh,
Sir, if I might ask you to remove your hat, please. I know you're under arms, but just if you could, please. Thank you, appreciate it. Kick out on me. Let's see how long it stays connected. All right, first item, late items, any late items for the agenda?
no.
Agenda approval,
I move to approve the agenda. A second?
motion's been made and seconded to approve today's agenda. Any further discussion? And hearing none, all in favor signify by saying aye.
Aye.
And opposed, and motion carries. And then minutes for past sessions, last county court session and the work session. And the move the Oregon border session. So from special session, April 9th, court session, April 3rd, work session on 3/20, and to move the Oregon border session on 3/20. Any concerns?
I didn't have any for any of them.
No,
Did
I
you want to do it
wasn't present
individually?
to one of them. and
Let's
so
do that one
might be
separately. Yeah,
Which one?
I'm trying to remember what.
the
that was.
9th,
That was the ninth.
right.
Okay, so a motion to approve, I will do them separately then. Move to approve court session on April 3rd, March 20th, work session, and to move the border session on April 20th, or March 20th.
I second.
Motion's been made and second to approve the sessions as noted. Any further discussion? And hearing none, all in favor signify by saying aye.
Aye.
Aye, and opposed? And hearing none, motion carries. And then the outstanding special session on April 9th, myself and Commissioner Doral were present for that one, and any issues, any amendments, changes? Motion to approve the special session minutes from April 9th. I'll make that motion.
I second.
And motion's been made and seconded to approve special session minutes from April 9th. All in favor signify by saying aye.
Aye.
Aye, and opposed? And hearing none, motion carries. That takes care of minutes. Next topic, opportunity for public comment. Any public comment today? I don't. Please
Okay.
state your name and
Barbara Kennedy. I had a few concerns really. One of them is the ordinance that was brought up at the last meeting regarding use of RVs as far as being able to inhabit them on private property. And I will say that I do realize that the Constitution was suspended with 9/11 and has never been reinstated really by, acknowledging the Emergency Act. But we always still refer back to the United States Constitution and things that we talk about. And one of them is enjoyment of your property. And this ordinance that was brought up at the last meeting regarding travel trailers and RVs being allowed to use as residence. We have hunters that come here too and buy property specifically so they can get hunting permits. And this is one of the reasons that I would prefer not to live in Burns and Hines is because I was aware of this ordinance in Burns and Hines. I was not aware that it affected the county. But as you know, if you know me, am a supporter of private property rights. And although I don't have an RV, I think people should be able to use them however they are. And this was brought up in the last meeting. There are more than 100 people in Kearney County that are living in that situation. So I would hate to see them punished for that. The other situation that I'd like to address is the MyWay contract that will be discussed further in the meeting. It's kind of disappointing to me on page 2, where there's a lot of mays. They may be projects to extend the last mile service to hard to reach locations, or they may include middle mile infrastructure only if the project will also deploy new and or improve last mile services to eligible areas. I would say that this agreement or memorandum is a definite plus for MyWay, more so than it benefits the county. And the real issue in Harmon County and most rural areas in Oregon is the middle mile. And so I guess I would like you to consider that in the wording of this agreement.
I would just like to make a brief statement here. It is on the agenda. That is an MOU rather than, and it was very well done, in my opinion, by our county council office. And it is for the purpose of strengthening MyWave's application for a broadband grant.
I understand that.
And nothing in it is, we couldn't put a lot on the table from the county. they're gonna reserve if they get funded. And we would probably support additional internet service providers or entities who want to do a good project and make us aware of it and it being acceptable to our vision. We would probably do something similar for other entities that do so. But the may and the whatever, that's a preference thing, I would think. So that's fine. The grant, this is to strengthen My Way's application for the broadband deployment program which includes millions of dollars. It is not anything that the county's going to micromanage. But we are in support of it in that they have been an active participant in the Southeast Oregon Broadband Action Team, or BAT, from the beginning. And nobody else is putting in for grants for Harney County, to my knowledge. They can do it without our knowledge, but then we wouldn't be providing support.
Okay, thank you.
Thank you.
Any other public comment? Yes, sir.
My name is Rob Frank. I just had 3 questions. My first question was, I was wondering if I just overlooked the minutes in the PDF version of the packet. Maybe I just skimmed over them, or if they're available in another place.
Did you look on the Town Cloud website?
I think that's where it was. I just followed the hyperlink that's on the county website.
In order to access each one, you have to go back to that date and then over to the minutes. So we approve them in this packet, but they're actually housed in the packet where they were done that date. And so it is a little confusing. Even I've had to train myself to look for those minutes, but you have to go into the minutes in the Town Cloud of that date, that meeting, click on minutes there to review them. It doesn't just have an automatic link in our packet that we did today that includes those minutes.
So the approved minutes go in the packet, which
They're within the Town Cloud, but with that date of the meeting. There's
That's our kind of official repository of the minutes.
But it does take a little training of how to navigate this.
all right,
And were you inquiring about past agendas and minutes, or?
for this meeting.
Yeah,
For
we
this
had,
meeting,
we had
agenda for this
multiple
meeting?
ones.
Yeah,
But they're all back in Town Cloud under each meeting.
When I was reading through the packet for this meeting, I didn't see the minutes anywhere, and I don't know if I had missed each, but if I go back to the meeting for which is in before, then I find.
Yeah, that's, it, like say, I would like to have a way that it would automatically generate into the packet, but I don't believe Town Cloud has that option.
My other question was, I didn't know if the budget was available digitally. I didn't see it anywhere, and I inquired at the clerk's office.
It's available digitally on the county website. Last week, I had our web administrator upload it to the website, so it should be on there. I'll take a look this afternoon or when we're done here just to verify, but I was told it was on there, so.
Excellent. Well, I just looked briefly, so I bet I can find it. It's on there. And then my other question, which is a little naive, but trying to get up to speed on these water rights. And I was looking, they use the acronym PTW often, and I was curious what that means.
Potential total withdrawal.
Okay, well, thank you very much.
Any other public comment? All right, not seeing any, we shall move on. We have no old business, new business. We have a request.
Under old business, I did have a follow-up that I thought of, once we started with the vector control contract. I didn't see it added to this agenda, and that gentleman had not joined us at the last meeting. I didn't know if he'd heard anything.
I haven't heard from him. I've got the contract in there. I need to get in touch with him and find out if we're good to go for this season.
Okay.
I heard a public service announcement, City of Hines driving in today on about.
Yeah, they've been doing
Okay.
that on the radio quite a bit. I hear it quite
Okay,
often.
yeah.
We are intending, and I have budgeted for most of the
Right,
cost
we're
will
just
come
waiting
into the,
to hear from him.
most of the cost will come in the next budget. And they start charging, I think, in July is when their fees start. So that's budgeted into this budget that we're working on. And, yeah, and as far as I know, they're planning on,
So will we need to put this on the next agenda? Do we need to review it?
It's, if you guys want to, I mean, it's within the amount that I can sign it and take care of it, or we can put it on the agenda item.
I think it's good just because we do have members of the public that do ask about, the vector control piece, so I would
Okay.
like it in a public meeting.
Make sure that it's on there next time then.
Thank you.
And I will have contacted him by that time also, and
Well, and I know that we had him lined up and it was just a no-show at the last meeting, so. We'll try again.
all right, then, back to new business. We have a petition from Oregon Desert Land Trust, Trout Creek Ranch, more commonly known as, to, for the county to, relinquish or vacate its, mineral rights to land properties that were obtained by them through tax foreclosures. When the county, right now, when the county forecloses on a piece of property through tax foreclosure, it retains, then when it's sold, it retains the mineral rights and road rights of ways for those pieces of property. These pieces of property are landlocked in between or in, I don't know how they were ever cut up this way, but they're landlocked with the total surrounding, most of them with the total surrounding property already belonging to, and the piece of property in question belonging to the Desert Land Trust. So we retained the mineral rights. We retained a geologist, Tim Smith, to conduct a survey. Preliminarily, it would appear that there is no value to any mineral rights, but as part of the statutes and the requirements, we need to do an order today that in the matter of conveying mineral rights reserved to Harney County to the owner of surface rights. This matter having come before the court pursuant to ORS 275.316 to address the potential transfer of mineral rights reserved to Harney County to Trout Creek Farm, owner of the surface rights to the following properties. And this is in the packet, so it's got the specific lot numbers that are in question, that they've submitted a petition for to receive those mineral rights. They're just trying to clear up their books, property ownership and everything, and I think it sometimes would be add complexity to any kind of liens or loans that they want to use these properties as security for, is what I would imagine part of the purpose is. So, per the statute, we do this part of it today and addresses our intent. And then, the court being fully advised in the premises now therefore finds that the public hearing to hear objections to the proposed conveyance will be held on June 5th, 2024 at 11 a.m. The hearing will be advertised for 4 consecutive weeks and finds that the court has caused an investigation to be made by qualified geologists in regards to the value of such mineral rights. Such investigation has determined that such rights are of little or doubtful value. The court hereby declares its intent to transfer those mineral rights. But we can't go ahead and do that just yet. We have to wait, advertise it. Has to be out there for at least 6 weeks. Yeah, for at least 6 weeks, and then we'll have the public hearing on it. And at that time, depending on the results of the public hearing, then we can execute the order to vacate the mineral rights.
I'd just like to make note that in the packet, it does say May 29th on the document instead of June 5th.
Okay, I changed that the other day and it didn't get changed in the packet. We'll update the packet. I did that just so that it coincides with the county court session. We'll just recess from county court and then convene the public hearing and then back into.
And so we do have 11 a.m.
Yep.
It does say 10 a.m. in the packet.
Yeah, I changed that as well too. So we'll get the updated order in there. So, I would entertain a motion for order in the matter of conveying mineral rights reserved to Harney County to the owner of the surface rights.
So moved.
Second,
Motion's been made and seconded for county court order, in the matter of conveying mineral rights reserved to the Harney County, and to owner of surface rights. Any further discussion? And hearing none, all in favor signify by saying aye.
well,
Aye.
Aye.
And opposed? And hearing none, motion carries. In this same matter, on those same pieces of property, there was also a request, a petition filed for, the right of way, the road rights of way that we retained on these properties. And again, some of these properties are encompassed by private property that we would never have a need for a right of way for. But there's another step in that, so we can't take care of that one today. We'll have to do it in next county court. Right, next topic is the zoning ordinance reference to continuous occupation of recreational vehicles. We have the planning director, Mr. McMullen, here today. You could give us some background on that and where we currently stand with that ordinance.
Sure. So it was requested that I provide some background and maybe some information as it relates to citing recreational vehicles in the county, or maybe residing in them as well, or occupying them. I put together a quick write-up to what I'm going to speak to and provide it to the county court for some informational purposes. At the beginning of this, as far as recreational vehicles go, the zoning ordinance defines them in a very specific way. And what I'm making reference to throughout some of this is this packet that I provided the county court. Under Article 1, number 162, a recreational vehicle, as per the zoning ordinance, is a vacation trailer or other unit with or without motive power, which is designed for human occupancy and to be used temporarily for recreational, seasonal, or emergency purposes. The manufacturer shall identify the unit as a recreational vehicle, and then there's a state statute reference in there too. As part of the request, it was in the background, the question came to an ordinance that discusses like the stay or occupancy of RVs from 2000, year 2000. And so I've included that in part of this. The ordinance effectively amended the Harney County zoning ordinance, and it's ordinance number 2000-42. The majority of that ordinance focused on the placement of manufactured homes coming from outside of the county in. So outside of our jurisdiction, like Malheur County or what have you. Was very pointed at addressing the age of those manufactured homes that were allowed to come in and be sited in the community. However, there was a small part at the very end of it that addressed building permits not being issued and the amount of time and that folks can reside within a recreational vehicle. And so that language I screenshotted right from the ordinance and put on page 2 of here. But it essentially says, or it does say that, I'll call them RVs, but RVs are defined in that section that I talked about and are not to be used as permanent residential structures in the county unless located in a permanent RV park or otherwise receives land use approval. In this regard, the following standards apply. And so it goes on to say that recreational vehicles or RVs are not to be inhabited for more than a 30-day consecutive period of time. Building permits will not be issued on RVs, i.e., or for example, electrical, manufactured home placement, mechanical plumbing, or even structural. And that RVs are not to be connected permanently to any kind of septic system. In 2009, and before I actually go there, I did a little bit of looking into what I could find for consideration of that ordinance from minutes of the Planning Commission who looked at it prior to the county court, and also the county court minutes to see if I could extrapolate some conversation or some direction from it. The Planning Commission had this language in its initial draft. And the minutes focused on what the majority of the ordinance was focused on. So unfortunately, there wasn't a lot of discourse there that was reflected in the minutes as it related to RV stays. When it went to the county court, there were some slight language changes prior to final approval. And they had to do with sub C, which is the RVs are not to be connected permanently to septic systems. That was added by the county court. However, that was the extent of discourse that they had, at least reflected in the minutes of September of 2000. And that's shortly after that is when the ordinance was approved. If you fast forward to 2009, and that's when I joined the club, we had a major project that was aimed at cleaning up our zoning ordinance, subdivision ordinance, and a comprehensive plan to streamline the whole thing. There were a lot of moving parts. And one of the many moving parts addressed some of the language in this subsection. And what it did is it changed sub A to read and provide another avenue for folks to temporarily use RVs if they were building their own place and needed a place to stay. So, and it reads, RVs may be temporarily inhabited during the time of construction for an approved dwelling upon the written authorization from the planning director. RVs inhabited for more than a 30-day period of time without said authorization will be considered out of compliance with the Harney County zoning laws. So that's what we have on the books and kind of where it comes from. If you look on the next page of that, you'll see, I'll jump into what state statute references when it addresses occupying RVs. And so it stipulates that a county or a jurisdiction, if given certain circumstances that I'll provide here, may not prohibit folks from living in RVs if the following are part of that circumstance. So if the RV is within an RV or manufactured dwelling park, then they can do that. It's allowed. Or if a home has a primary dwelling, their home has been destroyed or is in such a state of disarray that the home needs to be repaired after a natural disaster like a fire or a flood, then folks can stay in RVs given those circumstances. And that's what is cited under ORS 197-493. So if you look at what local code has, it addresses generally what state statute infers, is that outside of being in an RV park, if you will, or in an emergency, the county felt it was necessary to provide further clarification on the amount of time that folks can temporarily or be in an RV outside of this threshold that's established by the state. Part of the request also talked about a recent Senate bill. It was Senate Bill 1013, and it was approved, if you will, and is now effective law as of the 1st of this year. And it addresses and goes on to amend that statute to include an alternative or another way for RVs to be inhabited. And that has another pathway potentially. So if someone owns a piece of property and they live there already, there's a home established, then they can provide for someone to live in an RV on that property, which already has the single family dwelling. They can live on there as long as there's a rental agreement, and they provide basic services to them.
So more of an ADU, auxiliary dwelling unit.
That's how I would look at it. Yes, I think that was the intent. It's limited in scope, however, and so when it defines where these can take place, it defines it in areas of, or more specifically, rural areas. Rural areas in that Senate bill and in that language are defined as an area zoned for rural residential, as defined in ORS 215-501, or land that is within the urban growth boundary of a metropolitan service district, but not within the jurisdiction of a city. So basically, it doesn't affect cities. So what that doesn't include is all the other areas. So your natural resource zoned areas, EFU, forest use, or even some of your other areas that would be commercial, mixed, industrial, aren't on that list. So it's limited in scope, but it could be an opportunity for areas that we have designated rural residential as potentially a landing spot for this type of regulation, if you will. So that's what I've got for you, a little background, and when I will tell you, as far as from a practitioner standpoint, you have clear language that talks about what is compliant and what is not when it comes to recreational vehicles in that subsection. I will claim, and this is more candid than anything else, but I am certainly not a police officer. I am not trained to be one, and I'm not an attorney. But it does fall under my purview to try and find a good way to make sure folks are in compliance with the zoning ordinance. It's part of the job. It's not my favorite part of the job by any stretch, but it is part of what I do. And this is not an excuse, but one of the challenges you have in Harney County isn't the population. It's how spread the population is over the 12th largest county in the United States. And so without a little bit of resources to help kind of get there, you're left with your own devices as a planning director trying to get to what you can get to. And so it's not a perfect science, but we try and do the best we can.
Before we continue the conversation, sir, if I could ask you to take your hat off, please. No, thank you. So that's where we're at. I think the language is pretty straightforward. Do you know, so the statute itself kind of gives a minimum of where it's allowed and where it's not. What authority do we have, just if we decided to, just in case or whatever, what authority do we have to deviate from that? Or how much could we deviate from that through ordinance? Could we amend our ordinance to allow it and put other provisions in to help? Some of my concerns are that if you have camp trailers pop up all over the place, and even if it's on a 5-acre piece of property and they deteriorate, and then as time goes on, you have a dilapidated camp trailer that's sitting there, and who's responsible for getting rid of it? So, and I don't know if we could, I'm just thinking off the cuff, but it's require some kind of bonding or something for the disposal of those when they're, because ultimately I would foresee that these properties are gonna come back to the county in foreclosure, and then it becomes our problem.
I'm
Not in every instance, but I'm just saying.
sure. So, do we have the ability to amend our local ordinance to refine what we have? Absolutely. On EFU land, or on our goal 3 and goal 4 lands, our natural area, our resource areas, we are at the limitations that are provided under state statute more so than we are in our urban areas. So I'd have to do a little bit more research as to whether or not we have flexibility to change. I mean, we could certainly remove a timeline. I'm not sure if we could remove the language altogether, to be honest with you. However, that statute still plays true. And residing in recreational vehicles, which don't meet Oregon State Building Code for single-family dwellings, are not an allowed use under state statute in our EFU and FU zones.
I had a couple questions just to bring me up to speed. This is just kind of general. in our own language, in some of our zoning, language where we say, or otherwise receives land use approval. Briefly, what are you talking about? Would there be exceptions at a planning commission meeting made if there were an exception to be considered case by case, or does that mean, what does that mean?
It's very limited in scope, but one of the examples is right there in that subsection as it relates to being able to temporarily be in your RV while you're building your home that's been approved for you. There's one. The other one actually comes with medical hardships. And let's say you have a relative that needs your care and you need them to live on the property with you in a temporary fashion. That's another example of how you could approve a recreational vehicle temporarily under those circumstances.
Yeah, so is it just specific things such as you cited, or just the general judgment of the planning commission as well? And they just,
Well, so yes, it's very specific. The planning commission their job is to consider all of this information and then render a decision, but there's no magic wand. So as you know, not to infer that's where the question was at all, but it's they won't be in a position unless it's very specifically called out in the zoning ordinance to allow them to make that call.
and so any type of, permanently connecting to septic systems, I'm guessing that our on-site, professional, that there are certain septic, capacities that are approved, you know, for, different properties. And is that something that at the time of a situation where an RV is justified and within our ordinance to go ahead and permanently connect and that be like an accessory dwelling unit for some period of time, possibly a long period of time? Would that require additional work on the part of our on-site or adjustments to those regulations and rules so that, and additional workload, or is that not a concern?
Well, so RVs it is very common for folks who have a home already and they have an RV or two on their property, and for them to utilize their own septic system to dump in there, that's totally fine and would most likely be appropriate for those scenarios. So I'm not sure if we would need to step outside of the scope of that practice. However, I would need to defer to our professional on what the circumstances would be if there was something we need to look out for as far as DEQ rules are involved. And that's where she would come into play.
And I'm thinking that if the state passed saying you can do it one RV, then they're probably thinking that septic systems generally have the capacity to accommodate that without opening a whole lot. Otherwise, I mean, that's my guess, is they may be saying one's okay, but after that, who
Yeah.
knows?
It would be speculation on my part. I need to talk to our environmental health specialist to see what kind of challenges we would face there if we were to move in that direction.
And do we have specific ordinances for accessory dwelling units here in Harney County? Do we have?
We do not.
Okay.
We do have a definition for what's defined as a guest house in our zoning ordinance. And a guest house is very limited in scope, but it's there for what folks would commonly refer to as a mother-in-law's cottage. It's a guest room that's just detached. So it's not supposed to act as a separate dwelling unit per se, but could be used in that capacity, I suppose, for family or whatnot. It's site built as defined in our ordinance and has to be less than 1,000 square feet. And can't have a full kitchen. So basically, it can't meet the definition of.
Those are our rules or the state rules?
Those are our rules. It's in our zoning ordinance.
Do you know if they are compatible with whatever the state rules are on that kind of thing? Now that homelessness and things have, you know, become very large social issues and realities, and some of the more urban areas, you know, and suburban counties have route to allow more of that. I just wondered if in your professional dealings, if you're aware of other counties that have worked on that.
Yes, Deschutes County, of course, comes to mind. I'm in contact with them on a regular basis, but accessory dwelling units are an allowable use if the county moves in that direction in your rural residential or urban lands, but they are not an allowed use on EFU land, which is the majority of the jurisdiction that we have here. And an important distinction. But in those urban areas, we don't have any language that addresses accessory dwelling units. But certainly there's room for discussion. Absolutely. As you brought up, Commissioner, homelessness is a big problem. And that may be one area where more housing stock could be developed.
Well, and our ranches that have, crew that they hire that live on the ranch and those types of things. I would like to see private property rights allow for maximum ability to make good decisions. And if that means we need to update and change and adapt some of our ordinances or create new ones, I'd like to see that, but probably a lot more discussion to come. When you do become aware of a residence that has a violation, is this a complaint driven process? Or how do you implement these rules?
Yes, that's the straight to the point. It is a complaint driven process. However, there are circumstances where I'm on my way to the state tournament, I'm heading out of town and I see a potential compliance issue. And so I just see it myself and come back and still see that it's there. And we've got a sense of time and I send a letter out and say, it appears that this is the case. Let's have some back and forth and go from there. The compliance letters are not meant to be scary in any sense. They're meant to communicate a potential compliance issue. And we try and resolve that without having to get down any kind of rabbit holes, but it is a necessary part of it, unfortunately. But that's the majority of these are when I get a call from the tax office and say, hey, there's a new building coming up. This isn't RV related, but there's a new building out there. We don't have any building permits on file. Do you have some? And then we find out and we pursue that. But as far as RVs are concerned, it's complaint driven, or I see it with my own two eyes when I'm going somewhere regularly, like the highway or a county road.
Thank you.
Is there any language in any of this that, obviously the scope of where RVs can be allowed through the permit process is setbacks consideration with that, because obviously in town, we see that there's RVs placed in places where obviously they're in compliance with the setbacks of that, but within our own language, was that a consideration of if there is a permit allowed, that those kind of things are still followed so that, neighboring properties are potentially impacted by having said dwelling there?
RV parks are their own scenario, but on land that is designated for rural residential and say already has a home on it, for instance, you'd find an opportunity under, say, Senate Bill 1013 to implement that possibility. So the question then does beg, do you apply normal siting procedures to that scenario? And I would have to think the answer is yes. If it's going to be utilized as a dwelling of some kind, then you would expand your definition of what a permanent structure is, which your structural setbacks would apply to, and you would presumably want to implement the same provisions you would for an RV that you would for a structure with a foundation.
I think this is a topic that's great for discussion, but I would like to have a little better feel for the planning department, actual volunteers that serve on our planning commission to engage in this as well. Often it's their years of experience in those roles that lead to us being best informed when it comes to some of this, and I don't know how many of them were around at the time of the
At least
inception,
one.
but I'm pleased that I do believe there's at least one on there, and so I wouldn't mind if, some further discussion took place with that group, and then, further engagement with the court on it after that process, but
It would sound to me like with the EFU designations, in order for something like this to take place or to be permitted or cited, even if we got to that point, that the EFU portion is gonna have to be changed. Is that correct? That they would have to go from an EFU designation to a rural residential designation?
For sure, if you wanted to implement something that, like Senate Bill 1013, for instance, yeah. Those types of designation changes are not common because they're very challenging to pursue, especially in a limited scope like this. You have to do an entire plan amendment change to get a zoning change done on your property, and so there's justification and process there. I'm not sure, in other words, in short, I'm not sure it's worth the effort. But certainly that's a path we can go down.
But it does create a potential path if someone was really serious about pursuing it now that the Senate bill's in place. It does allow for that path to be pursued in the proper manner.
Yes.
And, my own thoughts on just the social impacts of all this to people is that on medical reasons to have an RV taking care of that person or whoever, I think we're gonna see more of that. I think hard times are hitting us. Not just Harney County, but, and I think a lot of, people can't afford to have their older loved one in a care facility. They're gonna do it as best they can themselves. People, lose their own homes and have to move to relatives and stuff like that. So to the extent we can make some progress on this, I would like to see us work on it.
I would agree. I would like to explore the options of what we might be able to do to amend our ordinances. And whatever that may look like to keep us to be able to still manage, not allow for creating a hazard in some ways, not just totally turning our back on it and ignoring it or creating ordinances that don't address the issues. So if there's something that we can do to help facilitate, I would be in favor of that and that further discussion.
Do you guys include tiny homes as RV use, or do you look at a separate?
They're considered RVs.
Tiny homes are RVs.
To the extent that you could draft up changes to our existing ordinances to comply with the new state ORS changes, just what would those word changes look like if we wanted to at least do something like that sooner rather than later, and then look at the big picture, in a more deliberative process over the next year.
Implement 1013 changes, is that what you're?
Yeah, into our ordinance, what would that look like? Maybe next time, just kind of highlight, just put in some language, run it by county council, and we can just see if that's even gonna answer the mail for now.
For sure,
And talk to the planning commission, I don't know whether we wanna
I
try to
would,
attend a meeting, and have that on their agenda, and us go to that, or.
no, in fact, I was going to follow up with the suggestion that maybe a joint work session is warranted. To continue the conversation as it relates to this topic.
And I don't pretend to envision what unintended consequences there are, I'm just talking off the cuff now. Someone who does not know the original intent way back, and if we're forgetting to consider anything, historic that we need to, but at least I enjoy this discussion. I want to thank you very much for doing all that, giving us the language of the different ordinances and documents. I appreciate that.
You mentioned Deschutes County. I would ask maybe that you do a little surveying of some other rural counties, Lake, Grant, and see what there's just recently passing through Christmas Valley. they either don't have it or they don't enforce it.
I think it's the latter, but then again, I know the planning director over there really well, so I can give him a hard time. But,
Yeah, recently as of last weekend, and I was, it looks bad. I don't want that in Harney.
No, there's cautions to be had on.
Yeah, you know, because it degrades property values from neighbor to neighbor even, so.
So, I'm putting two and two together, but when the county court was looking to implement that manufactured home date ordinance, it was aimed primarily at real estate values and health and safety issues that were built into that, to manufactured homes that were prior to 76, because you had asbestos issues. But it also, and I believe the city went through their own date change a number of years ago to like something in the 90s or a revolving date or something. It's common. And the impetus behind it is to preserve your housing stock for this type of housing, with not only health and safety, but real estate, and economy and housing and land values in mind. And it's not surprising that addressing recreational vehicle usage in that same vein was thrown into that particular ordinance.
And I would very much like for us to be all thinking about if there would be appropriate fees or whatever, if we ever come out with a process so that the county, if we end up holding the bag on some stuff, you know, that we are acquiring some funds to do so. And of course, if rental agreements need to be made, you know, then we can perhaps even ask our county council to come up with just a template of what a rental agreement, and this part
I
down the
think
road,
they're available online. I mean, I don't think it's.
Ma'am,
just to help people that
your
don't.
name
go
first,
online.
please.
I'm Cheryl Smith, and I'm the one that brought this to the attention. My question is, I have an EFRU zoning, but I have a non-farm dwelling. And so my question is, if you've got that in place, does that change that property possibly to something more doable for a possible placement? I don't know. Because I'm not farming my property, but I'm in that zone.
So, can I answer that question?
Yes, please.
So, the non-farm dwelling is the name for the type of conditional use permit that you were approved for your home. A conditional use permit is lined out as a use under state statute and local code that can be permitted in that zone. It doesn't change the zoning aspect of that area or your property. So it permits you to do what you're doing, but it does not change the zoning rules that are applicable to your property.
I guess my question was, maybe that's a little wiggle room. You know, if there's already a non-farm dwelling on that property, that maybe, you know, it wouldn't be such a big deal to have hardship trailer living. I don't know if that's I don't know.
I think definitely we have a lot of questions. We still have a lot of questions to ask and to research and find out what our potential options would be. So I think that's our action item, is to research this further, find out where we could go with it, what kind of accommodations we could make, if any, and
Can you add it as a conditional use allowance? Allow it conditionally? Go through that whole process.
For hardship, yes, medical hardship. Not as a single family dwelling.
Right.
yeah.
It doesn't meet Oregon State Building Code. That's the main challenge.
I don't want to do that too much.
Anything further?
Yeah, I just want to make one more comment, which is my concern is this part of the complaint driven. I travel over 30 miles one way every day to go between home and here, and I'd hate to see state how many look like non-compliance, and that is what led me to even bring this to the county. Because, you know, it's just not equitable, I guess. you know, we have lots of, we work on trailers. We know of a lot. So,
Without, you know, and I'm not gonna, the individual themselves, but on the letter that was presented to the county court that was sent from your office, have you made contact with that individual, or has that individual made contact? Has
Absolutely.
communication been started on
And
this?
they are no longer out of compliance with the zoning ordinance. It's been resolved.
Further, good discussion. I'm glad we're having this. Thank you for bringing it to our attention and doing the research.
Anything further on this topic? Okay, I'm gonna propose then, as Commissioner Shellman identified, we don't want to keep you guys from your duties any longer than we have to, so I would propose that we move the debrief from Lieutenant Worley and the Justice Center topic to the next item.
Can you just see if Justin Chase is available to hang on? He will be next, and he is,
From my way of,
yeah, I don't think that would take too long.
okay.
Yes,
Justin, are you
Commissioner.
there? Are you available if we move this schedule around a little bit? Are you available to hang on for a little while?
Yes, no problem.
Thank you.
All right, so then we'll move Lieutenant Worley up to the next spot then. And if you would, please.
I'm Lieutenant Worley with the Harney County Sheriff's Office. I'm the jail commander. I just wanted to give you a quick briefing. We've had a lot of really great meetings over the last couple of weeks. We were invited to attend DPSST's command council tour with Commissioner Doro. And we were able to brief them on our Justice Center jail project. The new director wasn't aware of our project, and so they sounded pretty excited. One of his executive team members came up and just did an outside tour of the property and took some photographs. So hopefully we can start opening up some conversation to get some support with our, you know, governor's office and the legislature, and with their connections, maybe just get more support if we ever do any requests in the future for funding. And then we also had myself and Judge Hart were invited from the circuit court to meet with the chief justices. We were able to have some great conversations with them, and they actually took a tour of our jail facility and our sheriff's office and kind of our court operations. So they got to see our deficiencies. And so they seemed like they were really supportive, and they were going to try to, you know, work with us and see what we could do, what they could do to help us in getting some of those funds, and then also the funds that we do have, trying to find if they can, you know, rework some of the strings that are attached to where we can start, you know, using those funds in different places.
That's great that you took those opportunities.
Yes.
Very good.
So,
And I'm really glad that the Chief Justice got to see our jail.
yes, they did.
Yeah.
I did, and then DPSST, I was not a DPSST, so we were able to, you know, exchange contact information, so hopefully we'll be in touch soon and get those conversations started.
And I recall from conversations between you and I think after the DPSST people, after you had that conversation, they were up taking some pictures and.
They were, yes, yes, they did. So, and then DPSST, one of the main topics during that meeting was getting, you know, training to the rural areas of Oregon, especially on the east side. And so this, you know, they've had this issue for years, and they've never been able to solve the problem of, you know, having a facility or a place where they could do training. They're not looking to have like a full training academy on, you know, a kind of another training academy in the state, but to be able to get that continuing education to people over here is very difficult. So they want to help us reach those goals, and it's their goal as well, but this would really solve the biggest majority of the problem of getting training over here to law enforcement. It would really boost our economy by having a facility that DPSST could put these trainings on and bring in people from all over the states to attend our trainings, and, you know, they would be spending money in our community. And so We really hope that DPSST and we can collaborate and really get some support behind this.
That was a great listening session they had here. They listened and these individuals, as well as our other public safety and fire related professionals were there. And they said that some of the things that was discussed at our particular meeting was the first time anyone had brought these up, and they were very engaged, wouldn't you say?
Yes.
I would say thank you for your diligence
Thank you.
and yeah, just taking the initiative to take the opportunity to bring these topics up to these groups as they come in and people as they come in and see Hardin County. That's one of the only ways we're gonna accomplish what we're trying to get accomplished is to get support from people from the west side of the state.
Yes, and just like Commissioner Doro said as well, is if people don't know, they don't know that we have the need and how dire need we do have. And so I believe in that meeting it was discussed, so I'm not sure exactly if they nailed down the time, but I know that it had been over a decade before the Chief Justice was that visit Hardin County. So it was actually and I don't know how long it's been since DPSST their executive board ever came to Hardin County.
I've never seen.
And they weren't going to, but I had called. I actually recognized which woman it was, and I just said, hey, can we zoom in then, since you're not gonna come, can you come? And they said, oh, no, we can't. And then a few weeks later, they added it. I mean, they didn't notify me, so I didn't know it was gonna happen. When I saw it on there, I was like, that's good.
I think it's really neat that we've had these, two really big events and to keep that line of communication open and hopefully we can just educate more people that don't see our needs. So
It was kind of neat that the director brought his whole management team to all these sessions. So they're not just hearing his debrief on it, they're hearing it. And it was, you could tell of course, they're in that profession anyway, but they definitely knew exactly what you were talking about, and they didn't realize in a lot of cases that's our situation, so.
Well, just for your information, I did meet with the governor in March and did raise this to her as well, especially with the changes with, Measure 110 and the assumption that counties of our size in the population formula would be given the minimum funding to try to implement those changes, and how insufficient that would be to be able to even do that when we don't even have a facility available to do that in. And so that was brought up to her directly, so that we can, and Rep. Owens in his closing statements in the legislature also brought it up and reiterated, a lot of counties in his district do face that, same situation where we would love to be able to implement these changes, but we can't due to the lack of facility space that we currently have. And so, we need to continue to engage with him as he spoke on that topic and continue to raise that. So as these changes are implemented with that measurement, that we also have the facilities needed to implement that within the jail system.
Did she guarantee you anything?
We don't go there.
That's great.
Courtney Crowell is also, Courtney Werner Crowell with Regional Solutions is also aware of it. So, we'll continue to engage on that side, but, these are little baby steps with Measure 110. Obviously, we only got some things changed and further movement is needed in the long session, but hopefully this would be an opportunity in the long session to engage in that funding piece, to then engage with what was implemented from the short session and try to make it a reality and try to find that funding pool. So like I say, engaging with Representative Owens and whoever our new senator will be really key in trying to access that funding piece that we need to have the tools to implement the Measure 110's changes.
Yes. Thank you very much for your time.
Thank you.
Thank you. All right. Then we shall go back on track here to the MOU partnership between the county and MyWay. Justin, are you still there?
Yes, Judge, I'm here. Can you guys hear me okay?
Can you hear us?
I can hear you. Can you guys hear me?
Yes, we can hear you.
Okay. Okay, perfect. Thanks.
Commissioner Doyle.
Yes, so what we have before us is a memorandum of understanding between Harney County and MyWave, who is an internet service provider in our community, as you know. MyWave is the only entity that I'm aware of that is applying for one of the two big pots of money coming out from the Oregon Broadband Office. This first one is called the Broadband Deployment Program. And MyWave, it has at least two scenarios that Justin is working on for the application, which is due April 25th. So it's almost, you know, it was only a 30-day period to submit this huge grant ask. And he became aware that you can get, you know, it will strengthen your application if you have some type of a partnership agreement with the county or the city or whoever they're applying for. And we looked at it, drafted up a letter of commitment and various other things, wanted it to be as strong as possible. So this MOU we had great support out of our county council office to make it a lot stronger than the one-page thing I had done prior, so that it will reflect the seriousness of our commitment. Now, Harney County doesn't have the ability to commit money to help and match, unfortunately, but it has in here the responsibilities of MyWave, the responsibilities of the county. And I'm very pleased with how well MyWave works with us. I'll let Justin talk to whatever he's comfortable talking to about, but yeah, I've looked over this carefully with our county council, and Justin has already signed it, as you can see. So should you both agree and we take a vote to sign this, I would like to do that in support of the application, because as far as I know, they're the only ones that are planning to put in some broadband to extend beyond the cities of Burns and Hines and start extending out. Justin.
Yeah, thanks, Commissioner Doro. I appreciate the time here to talk about this. I know there is some opinions. I know somebody spoke at the beginning there. I didn't catch who that was about this agreement. Just to add a little bit of clarity to it on the application, the additional bonus points are achieved if there is a formal partnership that is set up with a municipality or nonprofits. They give you some bonus points for that. In our particular case, we couldn't go to the cities because of the places that we're looking to do our grant are outside the city location. So the county made the most sense as far as somebody to partner with on this. Obviously, we're trying to do everything we can to expand broadband out to the entire community. The bonus points would definitely help us on the ability to be awarded the grant. Without getting into too many specifics about exactly where we are applying for and stuff, obviously this is public forum. I need to keep a little bit of that private, but the conversation about middle mile versus last mile, I will tell you that our grant application is not for middle mile service. It is for last mile. Our intent is, and we've kind of said this from the beginning, our intent is to serve all of the residents. We don't want to just build a pipeline in so that somebody else can come in and try to do that. Our goal is to be the best local provider that we could be, and that involves last mile service to everybody. So I know there's some statements in there about may include as far as last mile stuff and middle mile stuff. The comments I would make on that are that should we be awarded, I definitely what we're planning on for this is absolutely last mile, but in the future there may be other grant programs such as BEAD that we may be approaching the county about partnering again to try to support middle mile projects. Currently for this one, we are looking at last mile though. As far as the actions on the county side of the agreement, any support obviously is appreciated, specifically with outreach. Some of the some of the things that people don't know necessarily in the community about, we have to get a certain number of subscribers onto this system, or else we're literally losing money every single day. Just as one quick example, as of right now, we're estimating it's going to cost over $40,000 a year, $40,000 a year just in pole fees to be on the utility poles. So that's a lot of customers we have to get on just to cover the pole fees to have our cables sitting on those poles. So there is definitely a push to get as many subscribers signed up as possible as part of the grant program in order to make it financially feasible. So that outreach portion of this that is in the agreement really does have a vital component to the success of the project long term. So that by far is the most important thing for us as far as the partnership goes, and we appreciate any efforts the county can do to help us out on that. If there are additional things that MyWave can do to support the county, there's some actions in there about providing digital skills training out into the community. We're happy to expand on that if there's other ideas of things that we can do to help things in the county. Obviously, we value this partnership and would continue to work to do everything we can to support the county. So if there are other ideas, we're certainly open to expanding what actions are in there. But yeah, thank you for your support, and we appreciate it. Everybody cross your fingers starting April 26th. So.
Any questions?
Yes. I don't really have any. I think the MOU is pretty straightforward, and support that the county will provide. I don't have any issues with any of that.
And again, this is all contingent upon award. If he doesn't get which we hope he will, but if MyWave is not granted funding, then we're still going to work with them as moving forward and things as we do with anyone. But MyWave is the only internet service provider who consistently is at our BAT meetings and really knows he really knows Harney County as compared to some of the other companies that I would like to see at the table now.
Justin, I have a question on the poll fees, and that was kind of an interesting part that you brought up. Do you know what sets the rates with the poll fees? Is it just depending on which utility that you're dealing with?
Yeah, it is utility based. Some utilities, I believe the lowest that we've seen is $3 per pole per year. Some are as high as $14 per pole per year. So it just it really depends. Some of these areas are that doesn't sound like very much, but when you start looking at deploying thousands of poles, that gets extremely expensive. And that isn't even, maintenance and those kinds of things. That's just the actual fees to be located on those poles. So yeah, there's lots of little things out there that people don't necessarily think about on these deployments. But yeah, the utilities set those rates. To my knowledge, I believe it, probably has some, there's probably some alignment with, PUC rules and things like that. But, a window, kind of like in the cities, you'll have franchise fees and those can be set by the city, but there's a cap to it at 7%. So there is some windows. Some cities only charge 3% as a franchise fee, as an example. So there is a window there, but it is set by the individual entities.
Okay, I do appreciate the conversation around that. It's something, that we could potentially even work with the utilities on trying to, discuss more favorable rates, especially in counties like this where poles would be obviously utilized for this type of project. So, that's some outreach that we could try to work on.
Yeah, we appreciate it. That's on the operational side of things, that's a cost that that makes some of these areas extremely difficult. Even when we looked at wireless solutions, if we have to put up a tower that has a lease and power going to it, but it's only serving 10 subscribers, that's probably going to be a money loser just to even go there. And so, not to mention the capital to actually do it. So it's just, those are just some of the challenges we face in being super rural and low density. So yeah, if there is anything that can be done on the pole fees, that would be fantastic. I'm not sure what, what conversations can be had.
Right, but it's worth starting some conversations around. I do appreciate, a private entity engaging in this. That was kind of a hope that we've had in engaging with broadband, is that local private entities would want to take some of this work on and, try to utilize the funding that is available. So we do appreciate you applying.
Yeah, thank you. Yeah, we think this is.
At all.
Well, we think this is probably the best, this program and the next one are the best chances that Harney County is going to get to build out into the more rural areas. So we're pushing very, very hard to try to get as much of that funding as possible. So thank you for the support.
Thank you.
All right, so we have a memorandum of understanding before us.
I move to approve the memorandum of understanding between Harney County and MyWave as written.
I second.
Motion's been made and seconded to approve the memorandum of understanding as presented to the court. Any further discussion? And hearing none, all in favor signify by saying aye.
Aye.
Aye, opposed? And hearing none, motion carries.
Thank you both.
For your work on it. There is a little typo in my name that I'm going to go ahead and correct, Ian. So I'm gonna-
So Justin, it is signed, so we'll get that scanned and sent to you later today. Holly, thank you so much.
Thank you.
Thank you, Justin.
Thank you.
Will you send me his contact info?
Yes.
Next topic was Treasurer Heaney. Are you still there?
In the room just a
I
second.
know. Is she listening? That's all right. So next topic on the agenda is the administrative cost policy annual review, and then inter-fund resolution for inter-fund transfer.
So the policy, just before you, when it was created, it was discussed that it would be reviewed by the court each year annually, kind of during budget time. So I asked that it be on the agenda, and there's no change to it. And this is a topic, like maybe we could revisit this, like maybe every other year per se, if it, unless you'd like to see it presented to you each year as a reminder.
As I was looking over the budget that was presented, one of my concerns with this particular policy that we had is, especially with the fair fund, as we're looking at expending millions of dollars for a project, the administrative costs then become very high, but then it's also getting a transfer from general fund as it's acknowledged that it needs support from general fund. And so it feels like we're, doing a flip-flop. And one of the things also that I was actually going to bring up at the budget meeting, but this is, an opportunity to discuss it as well, is the funds that were dedicated for that project. Representative Owens had also written a letter to Grant County indicating that they wanted the funds for the project to go solely to the project and not to be used in a different manner within the county. And so, Lindsay's going to present that to the budget board as a, area of discussion. And so I don't know, I'm bringing it up here now as food for thought as we go into the budget with that. But yeah, that project is going to need every dollar it can to get the most bang for its buck, to complete the most items within the project. And so with those type of funding, sources, we'll call it, that come to the county, obviously, the normal budget that the fairgrounds, for example, would have an administrative cost in. But then when we have a project like this with state funding, then to tax it with the administrative cost, I would like to have some discussion around taking its base budget that it normally operates out of and having the administrative costs come from that versus the project funds.
I will say without the figures in front of me, and I think I can safely say this, the additional interest the Fair Fund has received over the course of the year, because those funds have been on deposit and not expended,
Correct.
is gonna cover that cost for them. And the cost is projected, so if funds aren't expended, the projected, administrative fee is realistically not gonna be the budgeted figure.
But the interest even helps support the project in accomplishing, like I say, just the maximum amount of project that can be completed, because we knew we were gonna have to do the project in phases anyway, you know, to build out enough restroom facilities, for example. And so I would like the county to be conscious of, if we really do want to get the most out of the project in phase one of the project, we do need to be conscious of any funds that can be available to be utilized during phase one.
And a thought process for this too is seems like you're constantly learning, right, in these positions, but with a lot of these big grants that have been coming to us over the last few years, I really think a better way for us to manage that would, instead of including it in the fair fund, it has its own fund.
That's what I was wondering as well, if that would,
And then the administration can come out of whatever's written in the grant per se, versus being included in this policy that we have just for operating funds overall.
well, and, you know, some grants do have a specific admin line where the legislative funds that we receive, none of that had the ability for us to write that in with the type of funding that was received. And so obviously in any opportunity that we can, we would want to write those in, but there's not always that opportunity. Like with these funds, we didn't have the opportunity to include that as part of the ask within that, so.
I would suggest we add a sentence, that second paragraph there where it says all department and funds of the county receive benefit and or services rendered by the following departments, and description of services. Reserve funds are exempt from paying administrative costs, and then maybe one additional sentence that says, on a case-by-case basis, the county court, may determine otherwise,
We
or
did
something like that.
language that kind of gives that latitude for, like, in this.
Or not, or is that opening a can of worms?
In my eyes, then it's just open for discussion. Anybody can come in and say, it's not fair that we get it.
Okay,
Well, I think
I
it's
mean-
okay to be open for discussion.
No, I do
myself,
too, but
I think,
I feel like it leads to.
no, I see what you mean.
To be fair, I don't know any way to put it, and maybe this is discussion we need to have about that, particularly when it comes to budget, about the fair, and maybe we move those funds into a separate fund and handle it that way. I mean, we.
yeah,
can
like
have
I
a
say,
discussion.
there, and I would imagine like some of the major funds that were received through your grant process, Melinda did have the opportunity to write that administrative cost into them, or did they?
I don't
In the
know that
past.
those were in there, and
Okay,
OEM requires us to have a federal indirect cost agreement, which the county doesn't have, which I'm looking into, like, how do we get one of those?
okay.
So that you can charge an admin fee.
So we currently don't have that.
Wow, that would be great
Yeah.
for that to get done, because
Yeah, and I think with federal funding, it's maybe a little more
Yeah.
straightforward if we had that policy to acquire that funding. With the legislature, it's a little bit of a
And I,
roll of the dice, whether in the funding we get that opportunity.
are we sure we don't have a policy on that?
I believe we do.
Because I was gonna say, years ago when we did a drug-free community grant, that was a federal one, and it seemed like there was, or we did something. This is a long time ago.
Whatever agreement I was given, wasn't the correct one, so I think we have to really file something.
I know we did one for DOJ,
Okay, so there's something that was, I'll have to ask OEM specifically, like, what are you looking for? What does it look like? Because it wasn't, whatever I received,
wasn't sufficient.
Wasn't sufficient, so.
That's good to
figure it
know.
out.
Yeah, if you can ask any of the counties, you know, that have their act together, see. if
And
we
I-
can-
Another thing I will say, like when this agreement was put together, it was during budget crisis, trying to come up with a way to replenish funds to general fund. And
Yeah, and I don't have a problem with it in general, like say, I'm just looking at it in this particular scenario with this particular.
but this particular policy, we could make it more, I mean, we could have a whole conversation about it and make it more in depth and much more clarity to it.
Right now, it's blanket.
Yeah.
And it's blanket based on dollar, estimated dollars of expenditures and the percentage then accordingly. I myself would want to nail it down a little bit more specific. If we put in a sentence that says, or as determined by the county court or something, that opens up a lot of gray
Yeah,
area.
that's too vague.
So I would want to nail down something that is specific with caveats, maybe, I know we end up with a lot of funds that are specific to a project or whatever, whether that be the Justice Center or the fairgrounds or whatever. But I think the case, if you're not careful and you don't do this right, the case could be made for just about anybody to say, well, my funds should be exempt from.
Because we're gonna need this, we're gonna need this in general
And
going forward anyway, for the county.
You know, this was drafted not in haste, but I mean.
Under duress.
Something, yes, under duress. And I feel like as a governing body, that would, I mean, be something like, and I can be at the table too, where we try to research and come up with plans and have county council assist us so that we're doing everything correctly. I think it needs to be a group effort where we come together to make the
So let's,
decision.
maybe potentially schedule a work session. I know that we're in the middle of budget process, but I do believe that we probably have time to achieve it, before June, obviously, to have a work session and try to feel more comfortable with the direction of this.
Well, the schedule that I have for the budget committee is, we have the 2 meetings coming up this week, Thursday, Friday. And then we don't meet again until May 2nd, for a few other departments, odds and ends. And then we don't meet again until May 30th, which gives us that time. It's still a proposed budget. It hasn't been approved yet. It's still proposed. But we have one last meeting, the end of May 30th, for, any of those kind of changes that we might want to put, implement and put before the budget committee to make adjustments before it was formally approved by the budget committee. So I think we do have a little bit of time that we could probably do a work session and decide on this and put a policy together. And then, I don't want to say adjust, but rework the numbers so that this would affect the fairgrounds' budget and our overall budget as a whole.
And, another part of the conversation is, especially if, say, for example, with the jail funds, if there is an administrative cost that is available with those funds as well. And I don't know how that language was written up, as they were received, so that's something we need to look into, but, if we're projecting that money will be spent within this fiscal year, we write that in, that amount of money will be received back to general fund, and then it isn't, that does have a negative impact too, and that's where, I want to be cautious as we look at this policy, that we don't set ourselves up for, if that funding were not to be expended within a calendar year, but yet we calculated it back in, that can put us in a situation, where we didn't receive that revenue and, it was essential, to have within that general fund to come back in. And so I think that we need to, have some thoughts around that too, as we look at, especially out of the norm. Like I say, the fairgrounds has a normal operating budget that they do operate under that's predictable. But then when you have a situation like this, where if all the funds aren't expended, because the project will go just past July 1, so some of them will be expended, but not all. But like I say, with these state funds, there wasn't really an admin carved out of it, and that, you know, is a topic of conversation to be had, but, you know, I would want to set us up to be expecting revenue that we then don't receive, due to this administrative cost.
You can look at this, just for discussion, you can look at this for two purposes. We're either taking these costs at a specific rate, and a lot of times federal grants are 10%. You know, people pay 10% administration right off top of federal. I mean, it's just as an example. And we can utilize that for bolstering our general fund, but there's a cost of doing business and there's labor involved. So I would not propose completely eliminating myself, and we can have this work session, but I would not propose totally eliminating an administrative fee on grant dollars of any kind. But maybe we look at it and decide, well, what does it actually cost to take care of monitoring and requesting reimbursements and the labor that's involved there, and put a cap on it potentially, something along those lines.
And I think you bring up a good point, especially funds that you do have to go through the reimbursement process are more time consuming versus those that you have on hand. And then that department head's doing all your grant reporting. And so, you know, depending on money sitting here that's already been allocated to us versus funds that you have to go for reimbursement, it is a different scenario in the amount of time that consumes.
But even if we have them on hand, we're getting invoices and they have to be paid, you know, distributed and paid through our AP process or whatever. So there's even times, there's even labor, there's still labor hours involved, whether we have it on hand or reimbursable. That just for discussion, and I think those are things that I agree. I think a work session on this topic would be good. Try and do some research, maybe what other counties, how they impose their administrative costs, just as something to go by and so the starting point.
In your next department head meeting, if you would also, you know, bring this up as a topic, so then I can get us some feedback as well. I would appreciate that.
Yeah, and I would suggest definitely doing that, and that way those of us who are writing grants can also make sure that
Conversation.
we have,
Right.
you know, you add a little extra to your grant to help cover more of those costs. Some of those grants don't have the 10%.
We have somebody online.
That's true.
He didn't mean himself.
Rick, is that you?
Permit application. And it says associated with,
Doesn't realize.
you haven't gone through the plan.
He's joining for a few minutes down the road.
So then we'll table this for the time being then. Try and get a work session going and get a policy in place before May 30th, and we can.
I appreciate you continuing to bring this up annually to us. Thank you.
Next topic then is resolution 2024-10 in the matter of interfund transfer of appropriations within categories for public health, RHC Fund 245. Looks like a transfer from reimbursed items or from administration to reimbursed items.
Correct, so, the RHC has a line for customer refunds, basically, so if a patient comes in and pays, and then insurance covers more than they owe the patient, you know, a nominal amount back. Their billing person has been really diligent about making sure everyone gets their refunds. They had a small budget of like $3,000 and they need more. So there was enough money in the administration left over that was an easy fix. And then that will allow for them to expend what they need for the rest of the year. And they're aware of what their balance is so that they won't go over budget.
Okay, and in the budget process, I haven't necessarily paid attention to what that number looks like.
And I'm writing myself a note
I was
right
gonna
now.
say, okay, let's make
Because I
sure.
want to look
it's
at it and
on
make sure,
for-
yes.
For next
I
year,
think
that we,
we discussed maybe upping it around $2,000, which should be more than enough. It's 3 this year. And we're upping it some.
Well, yeah, it's gonna come out 4,900 is level B here and so.
So, and I'll get with
Yeah,
the
we need to make
managers at the
sure.
RHC and whatnot, make sure that we're up in that to be
I
adequate.
must have had the wrong insurances. I've never gotten a refund.
So with that discussion, I would entertain a motion for resolution 2024-10 in the matter of interfund transfer of appropriations within categories for public health and the Rural Health Clinic Fund 245 in the amount of $1,300 decrease from administration and a $1,300 increase in reimbursed items.
So moved.
Second.
Motion's been made and seconded to approve resolution 2024-10 in the matter of interfund transfer of appropriations within categories for public health and rural health planning fund 245 as described. Any further discussion? And hearing none, all in favor signify by saying aye.
Aye.
Aye. And opposed? And hearing none, motion carries.
Thank you. Thank you.
Next topic is, looks like Rick just signed off. I'm gonna get into his intergovernmental agreement.
His email was very thorough. It'd be nice to have him on for this.
Yeah, I'm gonna,
I did read it.
yeah, I've read it too, and it looks good, and, I had a couple of questions initially that were answered by email. And I'm good with it, but I think let's hold
Yeah.
off for just a bit in case he comes back online, and let's move ahead to active shooter class and emergency management.
Do you want me to introduce myself?
For the record.
Yeah.
Melinda Todd, Hardy County Emergency Manager. So last Thursday and Friday, I had LSU here to do active shooter, run, hide, fight, and stop the bleed training. Day one, we had about 31 staff and community members, and then 30 the next day. We didn't close the courthouse, but most of the courthouse participated during the exercises, and we locked the doors. We didn't have anybody in here while they did simulation of gunfire, which was interesting. We had our state agencies, so OEM came, and we had the hospital and a couple of extras outside of our facilities. Pretty much all of the departments except for one in the entire building participated, so. Well, I guess 3 technically, so. but so we have-
Are you including county court in that?
No.
Okay.
That was me.
I was like,
They were presented. But we had some really good team building, I think. It got everybody out of their comfort zones. They had to go to floors that they're normally not on and learn to barricade doors and, run, hide, fight. And work with people that they don't normally work with, and it was very eye-opening even for me. I'm still learning, like, there's, some hidden places, I won't say where. And, like, I wasn't aware of in the building because I'm in the basement. So, I mean, we got the courts to close for 2 days, other than their little half hour that they had to do each day, and it was very successful. And my report here. So all my reporting is done, sent into OEM, and we are complete for exercises this year. And I just wanted to read the email I got yesterday. It said, I would suggest that 2 operation-based exercises goes above and beyond the stated requirements, and you and Melinda Todd have met the EMPG exercise requirements for the year. Congrats, you put in some damn fine work, and you should be proud of what you've done to improve the preparedness of your community.
I would echo that. You're doing a great job.
Very well done.
I will echo, having, and this was a long time ago, and emphases were not the same as they are today. But, once upon a time, I wore the hat of the emergency management coordinator in the county as well, when I worked for the sheriff's office. And I was an active shooter instructor during my previous time in law enforcement. The efforts that it took to coordinate this and put it together, outstanding job. The instructors, are kind of an industry leading entity across the country that have taken up this kind of training. Very professional, very knowledgeable, very good quality of training. Again, thank you very much for your efforts, and it is duly noted. Thank you.
Curious, Holly, did you get this big?
I sure did.
Okay.
And I wasn't able to attend the whole thing, but I did represent the part of it.
Holly threw herself in front of the judge when the shooter was shooting, right?
Yes.
Everyone for the.
Yeah. Anything else, Melinda?
That's it, right?
All right, did you have your after action yet?
Yeah, it was yesterday.
You did yesterday, okay. And how did that go
It
overall?
went well. There's some really good discussions. We've got a list of things to improve. A few things on the list to see if I can't get some grants for to pay for some improvements. But I won't give details on the security pieces of those, but.
Yeah.
We can,
But good, and just the participation in your after action
Was really
and
good, yeah.
the comments and
Yeah.
input and everything, good.
yeah, everybody really enjoyed it.
All righty, so I think we all got the email. Next item, and I'm gonna skip for just a little bit and see if Rick comes back on, but the last item on new business is a draft resolution for recreational immunity. And I put it on here for discussion. I think we just got it a few days ago from Audrey.
Yeah, and I
County
have
Council.
not had time to actually, I just skimmed it, but I had not had time to really go into it.
I'm glad she did that because that has been a discussion in, I think, on the governance, AOC and Association of Oregon County Steering Committees, et cetera. And while I am by no means totally read up into it, as soon as she sent that, I went, I'm so glad she's sending that. Means she's seeing other counties say, because you have to opt in to this immunity from liability for the use of trails and other things in the county. So let's read it over for next time. And if we have any questions, fire them to whoever we need to.
Yeah.
But I'm very pleased that she thought to do that.
Yeah, no, very proactive on their part, and I appreciate their efforts as well as our county council. This, for background, there was a case in Lincoln County, I believe it was, where an individual was transiting public pathway. I think anytime you're transiting public pathway, it's really pretty recreational, but the individual's argument was that they were going from their parked vehicle to some other event or something.
Yeah, there was a claim that it was non-recreational.
It was non-recreational, and they won their claim. So it caused.
They fell or hurt themselves.
Yes, yeah.
Yeah.
So there was a claim, they won their claim, and it caused a lot of concern around the state and recreational immunity, public facilities. And so with some legislation passed, and I don't know all the verbiage, but the legislation was passed during the short session to help, I think, define a little bit more in what is recreational and what facilities or what issues cities, municipalities and counties could be held liable for. I think it just kind of cleaned things up a little bit. And this here, obviously, this is a result of that legislation. So that's kind of the background behind it, and it's most definitely something we should be concerned with for future cases.
It's just, again, I'll have to look into it myself, but do you know why an entity must opt in and it wasn't just done?
I don't see it in the resolution anywhere.
I ought to,
A question.
that would just be nice to fill in that blank. And it's probably easy to find, but I don't.
Well, and I think this, I know as I came on the court, we've had some initial discussion, but I know that it never really came to fruition, that we sat down and went over some of this, but what properties that the county actually owns that would qualify and fall under this would need to be reviewed. Because we own more properties than I think most of us are aware, and to what nature are they considered open for public use and for recreation. And so that's something we need to spend some time around and make sure that we're aware of, and what does apply to that, what doesn't, and if we need to make some formal, designation of certain properties versus some that are not open for recreational use.
Whether
That's,
that
you know,
has
it's
any
this topic
implication
came
for
up,
fairgrounds,
you know.
Beaver Park,
Well,
all these
and
other
then even
things.
that other property that, you know, the county owns and then even, you know, any foreclosed properties that we have that are out, you know, in the south end, anything else that the public could come across. You know, it kind of, that's where my mind went with some of this.
Oh, the Albert Desert area, all down, oh my gosh, that
You
is.
know,
if
not
it's
to freak
county,
you
if
out.
they're
We
county.
don't have any
No, I don't
Okay,
think that we
just
have
making
any.
sure.
Well, but we have had little parcels of land here and there, and so what, you know, what is it that really designates it as such, and do we need to formally define that on our end?
I mean, it sounds pretty straightforward and just in section 1 of this resolution. In pursuant with or as on behalf of the county and its elected officials, officers, employees, and agents, Harney County hereby opts into the immunity from liability for injury or property damage arising from the use of trails or structures in public easements and or unimproved rights of way as provided by. That's pretty, I mean, that's, my question would be, are there any instances that this immunity would not cover?
Yeah. And it does it depend on what designation the property has as far as public use or not versus county owning it?
Yeah.
You know, there's a little bit of that, and
Yeah.
I'd like to spend a little time thinking about, from our end.
If before reviewing this or executing this at the next county court, if any of those questions that you have, we could maybe put them together and send them off to Dominic at once. I mean, cause like I said, my question first off is gonna be this. I understand, you know, our different properties that we own and what they're designated for, whether it's a foreclosed piece of property that we're just can't get rid of,
Yeah,
or
system holding, and we're kind of on because of another issue in the legislature.
because there is some movement on that too. I just haven't had a chance to get to it. So hopefully we can start to liquidate some of that stuff.
Like, you know, where are our unimproved rights of way, for instance, I don't even.
Well, I would think that would kind of go back to like these foreclosure properties that we've held the rights away on when we sold them.
You mean mineral rights?
No,
Oh, the
the
right of
actual
way?
rights away.
Okay.
Like, any tax foreclosed property, when it's sold, the county retains the rights of way, the vehicle road rights of way, and the mineral rights. So in these cases with the Desert Land Trust, we just retained the right to have a right of way should we choose it at a later time that we would need it. But obviously it's landlocked and we would never use that. So that would be an unimproved right of way. Whereas, well, even the recent one that we did for the gentleman in Crane,
Had
the
that
alley,
right away.
it was a right of way, but it was unimproved. It was never a actual road or anything put there. So I think that would be the definition of an unimproved right of way. So anyway, I just wanted to put that on here today, just for discussion, just to start that topic off. And then the last thing then we have to cover, and I don't see Rick has rejoined us, so is the intergovernmental agreement for building inspection services between Harney County and Klamath County. I think this agreement aids both counties, helps us work together in permitting and inspection services, providing those that have the skills and the certifications amongst each party in helping each other out. Obviously, it's one of my questions was payment, and it's just paid as needed or as the services are provided. And each entity is responsible for invoicing those fees to the other. So I had that, and then the term of it. Obviously termination, it has the standard termination clause, but the term of the agreement is.
It shall not expire unless terminated in accordance with section 8. And section 8 says,
Duration, it's under duration, there it is.
At any time, the 30 days notice, it doesn't talk about,
That's a termination
Length.
clause.
yeah, I'm not seeing a,
So each party has the right to terminate, within 30 days notice. In writing. So as time goes on and we evolve and either Klamath County or Harney County doesn't require the services of each other, then we can terminate it with 30 days written notice. Those were my questions. Any questions from, those were answered, so.
no, it was well done. And then we made the corrections on county courts, the board of commissioners kind of thing. And, I think this is a great, path to having two counties, achieve some of their building inspections and work, and for us to generate some fees and income. And I appreciate they're taking that initiative to get this before us.
It all goes towards, excuse me, one real quick, it all goes towards the goal of our building and planning department of being a one-stop shop. And quicker turnaround times. Not anything derogatory against having the state provide these services for us, which they have for a long time. But they're doing it for a lot of counties. So the workload for them causes time delays. So this will be a better service to the people of Harney County and Klamath County.
Right, and that's what I was just gonna say, that's the consistency that we, we're really hoping for, and I really commend Rick for, helping us get there, it was a great opportunity when he was willing to come and work for us, and to bring these skills and these connections to the table is greatly appreciated, so. I know he's not on, but we'll, thank him in hindsight for this work that he's done.
So with that being said, intergovernmental agreement for building inspection services. This agreement is made and entered into this 17th day of April 2024 by and between Klamath County, a political subdivision of the state of Oregon, and Harney County, a political subdivision of the state of Oregon. And then recitals and the articles within. It's online, available for review by the public. I would entertain a motion and any further discussion.
I move to approve the IGA before us, that you just specified.
Second.
A motion has been made and seconded to approve the intergovernmental agreement for building inspection services between Klamath County and Harney County. Any further discussion? All in favor signify by saying aye. Aye.
I,
And opposed? Motion carries. And just as a comment, this was all reviewed by county council, so. All opposed, I think I said that, none, not hearing any, motion carries. So I'm gonna go ahead and top up here into this 10 agreement made and entered into this 17th day of 2024. And Harney County dated this. April 2024.
We'll need to make sure the council signs.
Yeah, sometimes they do that, and sometimes they don't, so I'll see if he needs to do it.
oh, do you have our electronic signatures and all that stuff? Do you know?
I believe so. Should we used to be on file with your desk, but.
And that takes us to the end of new business. Any correspondence? Oh.
I can, explain that one if you want.
Sure.
So, this is a response from the Oregon Water Resources Department to some questions that were posed to them from some of the RAC. In particular, Mark Owens had looked over their proposed PTW and the 2018 data that they provided and had requested clarification on the graph. Given the calculations, that were developed to ensure that as we were trying to communicate about what potential, regulation or voluntary agreements occurred, that we were all working from the same numbers essentially. And this had been requested back in, I almost think October, November, and we finally have clarification that these are the proposed graph and numbers that we're going to be communicating with. And so that's been a challenge as we were trying to get information out to the public and just try to make sure people are informed about the process of the RAC, where it is currently, not knowing if the numbers that you're trying to communicate were also the numbers that WRD felt comfortable in communicating was, kind of an essential step forward as we work in the RAC process. And so it's nice to have this. I actually have a meeting coming up after county court where we're going to be discussing some of the process with the RAC. We, as in some of the RAC members, did speak to the Water Commission department, the Water Commission during their last meeting and asked them to help us look at the timeline of the current RAC process and developing the voluntary agreements that are being suggested in extending that timeline so that they could actually be achieved. December would be a very hard timeline to try to achieve voluntary agreements that the state's never developed before. And so it's kind of an ongoing conversation of if we're going to try to do this, we need to make sure that we're building time in the RAC process to be able to actually get to that and accomplish it prior to the RAC having to close. And so there's a lot of communication going on around that. As everybody knows, there's an interim director. I know that they are also working on hiring an actual director. So during this RAC process, we may have a change in directors, which can have its own hiccups along the way. We'll kind of wait and see where that lands. I know that they had final interviews with the candidates. So currently we're working with Director Woodcock on this issue and trying to, make sure that we're all communicating well. And so this is a response to some of the questions that were asked to OWRD to clarify. And so they canceled the April RAC. They have one tentatively scheduled for May 30th. And so we won't really have an opportunity to communicate back to them as the group at large with this correspondence until then, but there will be some communication prior in, just asking any clarification that's needed.
So if Commissioner Shellman, on this table that they attached to the letter, in the narrative, they say that Perry Buchanan and Sylvie's had incorrect PTW and that, so does this reflect their correction?
That is the assumption, yes.
Because
Because that was what was asked. There was some, with Sylvie's in particular, you have your municipalities rolled into that, and the municipalities have large amounts of water that could be available to them that they aren't currently using. And so when you look at the calculations for Sylvie's alone, if you have to calculate in the municipality's full potential use, then that changes your actual irrigation use within that according to the potential total withdrawal being set back at 0. And so those were things where we needed to, have some clarification around, well, are you calculating the municipalities out at full potential use, even though they're not using those? And so that's part of the ongoing discussion and that, there was some numbers within the Sylvies that we needed clarification on, for example.
Just not having the other numbers to see that they've corrected it. Just wondered. Is the community-based water planning collaborative? I know the surface water stuff's getting closer and then they will combine and then they will have their final report. Is that just basically something that the RAC uses, nice to have, but would not?
Are you aware that they presented at the last RAC meeting?
I looked at Holly's email from a day or two ago saying that the next meeting, what's on the agenda, and I looked at the timeline and it looked like the surface water is still a few months out and then the combined. So I was just wondering if that
So they.
is gonna have any impact on the RAC.
Well, yeah, because she actually did a presentation of the groundwater portion that was presented to the commission. So the commission allowed us, which I feel like we're always asking for exceptions, but we did. Normally, they don't review your plan until both pieces are completed. They did go ahead and review our groundwater portion. And so the information that was approved through the commission process was presented to the RAC at the last RAC meeting. And so that information can be considered by the RAC, going forward in the process as well. Voluntary agreements was a huge part of that was developed within the groundwater portion of the community-based water planning. And so some just legwork on like water districts, something that had been done by the community-based water planning and engaging with some groups that are familiar with that. So that information was presented as well as allowing stakeholders to be able to go in and review a lot of that discussion that had taken place around that. So, that's some important legwork for folks to be able to look at that's already been engaged in. There's, people that have looked at the basin and potentially how that water districts could look here. And so, their work that they've done in the groundwater portion is weighing in currently in that process.
So with the timing of the surface water, when that gets completed, how do you think that may impact the RAC timing for?
It won't have an impact on the RAC per se, because when we went out for the community-based water planning, we agreed to go through the planning process, present to the commission when it is finalized. And so our plan will be presented as a whole as they integrate the plan, which is the final step. And that won't really change too much where our groundwater portion was already reviewed by the commission. If it hadn't been, then there could potentially be some, changes.
Do you think there might be some changes in the RAC's direction with that having been formally presented?
There's a lot still up in the air, especially even with the graph that's presented. It's broken into the 15 subbasins. There's still a lot of conversation around whether that's the direction that should be taken. When you look at the data that surrounds that, it's challenging in some of those sub areas to really look at those and say that there's no interaction with the sub areas around them and that they can really be delineated out as their own separate subbasin. And so there's a lot of challenges with breaking it into 15. It's one way to do it. It hasn't been settled on that is the way that it will be done. So that is still very much a large discussion part of the RAC is what is appropriate for breaking out areas for regulation or voluntary agreements.
And who will be taking the lead on the voluntary agreements work, you think?
It's already currently underway with entities engaging with different legal counsel that are familiar with that. And so there's voluntary agreements that are being worked on to eventually present to OWRD
On their own?
on their own, but then OWRD had said that they weren't going to start the voluntary agreement RAC process, and they're looking at potentially starting it alongside of our RAC. And so it gets complicated very quickly if you aren't going to allow one thing to go forward and to get legs, and then you're going to bring another one that would potentially dictate to this one.
Right.
So there's some of that that's in motion, but I'll keep you posted as we know more. But it's a very challenging process in trying to go through this because, from the county court's perspective, I tried to, look at things at large and make sure that, economically, it's not just an impact to our water rights, it's an impact to our businesses. It's an impact to our utilities, the cost of utilities here. I've sat down with, our utility providers here, and, if you look at the potential amount of regulation that was originally proposed, nobody would be able to afford the power bill, domestic or irrigation, to pump water. And those are the larger impacts that we have to be able to navigate in this process, because when your utilities are based off of a major portion of it being utilities that are providing irrigation power, and then if you delete a lot of that, the rates are already changing just due to the BPA negotiations that took place here recently. But then you would see exponential rate increases that have to be navigated through all this process as well.
I remember, Kearney Electric mentioning 300% increase as just one, figure that was thrown out, is that if the irrigation is curtailed significantly, then the remaining, electrical clients and users, their bills would go up significantly. And, you know, and he used the term 300%. I'm sure that can change.
Well, the 300% that he actually brought up in that meeting was, OWRD had said that, that there had been a 300% increase in groundwater pumpage, and he said according to his data, it had only been 100% increase. And so he was actually arguing the data point of what they were seeing had been brought online versus what he actually sees in pumping utility data that had been brought online. And so that's what that number
Yeah,
was.
supporting and corroborating data.
Yeah, and so he was, you know,
Yeah.
questioning,
But it-
300% versus what he's actually seeing in the utilities.
And we know that the irrigation, bills are what pay Kearney Electric to stay out of the red anyway. As a matter of business model, and realities. Well, thank you for that, clarification.
Oh, don't put that button.
Like,
That's panic.
new.
Panic at the disco.
Somebody should tell me if I'm sitting here. I could have needed that thing.
We won't panic. It'll be all right.
All right, anything further?
No.
Well, just so happens as water issues come up today, this morning, received an application from Treetop Farms, Treetop Ranches. They have some existing water rights that expired, and I'm not, and I'm just gonna mention it today because I think I need to do some due diligence on this before.
Yeah, go talk to Dally if they
Yeah.
have any questions or concerns.
But they, cause I wanna identify the location of it better and, the history on it and everything else.
Are
So-
these surface water or groundwater that you're referring to?
Groundwater.
And you'll start probably seeing some more of that there are some that are starting to expire in the permitting process, and there are some that are actually getting denied in the permitting process as well, but I've been made aware of that, that was never the case before.
So what is this document, asking the court to do?
It's not asking us anything, is it?
Well, it does, it requires a signature, basically just a review signature, approval signature from the court. The last one was signed in 2006 by Judge Grasty.
So
And this,
I would suggest that we review and
Let the county council
yeah,
advise on that, because usually we don't approve, I wouldn't think.
so
I would like to know why,
States do.
what is our role in that approval? I'm not aware of our role, so I would like more information. Do we each have a copy of this?
we don't, because I just got it,
Okay,
I just got it like maybe 30 minutes before.
okay, if we could make copies of that, then I'll review.
And I just wanted to, in general deliberation, kind of bring it up, just to let
Is
you
there
know.
a timeline when we need a acknowledgement?
He didn't say, did he?
Sir, you have his contact.
Yeah, I've got his contact information. I can call him. I'll call him
Well,
back.
yeah, I know. That's their general manager for operations here.
So they didn't, they didn't really say what their expectations or needs were on that, but I just told them that we would look at it, review it and get back to them. Scheduling,
We'll be scheduling a work session. For the administrative cost policy.
I'm out of area next week.
yeah, I'm only available the first 3 days of next week myself also, so probably the following week. The 29th, got a couple of potential things, but I'm pretty wide open on the 29th. The 30th, I'm wide open.
We have budget approval right on the 30th or that budget meeting.
Oh, yes, we do though. That,
And then there's the Division 512 from 1 to 5 p.m.
Are you looking at May?
Oh, I'm sorry. Are we still on April?
April.
All right, thank
Wait a
you.
minute.
Thank you. I'm moving forward.
I'm currently open on the 29th.
I could do 29th or
so
30th
April?
if you need to.
Yeah, okay, those, yeah, so April 29th. Like I said, I've potentially got a couple of things coming, but they haven't been scheduled yet, so first come, first serve. So I'm good on the 29th. What time we wanna?
Do you wanna check with Bobby Joe and see what her
Yeah.
availability is? And
Okay.
then, like I say, I'm pretty open, so you check with her and get it scheduled. That's what I'll put on my calendar.
Mid-morning or later would be great, but I will come early if you want it, if that's the only time.
Okay, tentatively April 29th. I'll get back to you on that.
I do have one thing, and that it's jumping way ahead to June. June 5th is a county court date, and I understand we were gonna have a hearing or in the process of something mentioned today, but I will not be able to attend that day.
Okay.
I can do the day before or after, or you can have a meeting without me. Just letting you know.
So that's for the mineral rights hearing. We can keep, other than that, we can keep the agenda light.
I mean, it's possible that what is preventing me would get canceled, but at this point, I would not even be able to zoom in. So you all can conduct it without me.
Okay.
Noted.
So unless there's any real. What I'm looking for. Disagreement, whatever, I would just like to go ahead and go on with June 5th schedule meeting. I also then, looking at the calendar, June 19th is a holiday, which is the second Wednesday of the month.
Oh, that's right. I
It's
forgot.
Juneteenth. So I was gonna propose that we move county court that week to June 18th, the Tuesday before.
But there's potentially an AOC 2-day retreat, the 17th and 18th of June, unless I've got those dates wrong. And then there's,
Or the 20th, the day after, Thursday,
that would be fine with me. Are either of you planning to go to the Eastern Oregon Economic Summit? That's those 2 days, 20th and 21st. I'm
I
probably
haven't
not.
seen anything on it.
I
Don't
I
remember.
scribble it down in pencil when I read the emails, and then whether I keep up with it appropriately, not always 100%.
Is that the one up on the Grand?
Generally in that area, sometimes Hermiston, sometimes.
You attended last year.
Is that the OTEC though?
No, that's the,
Oh, I didn't go to that one last year. I know what
Eastern,
you're talking
it's,
about.
some women's coalition.
Oh,
That one?
okay, I did see that.
I think that's the 20th and 21st of June. I'll be more involved in either zooming in or slightly participating in the Association of Oregon Counties one on the Monday and Tuesday, but I probably won't be involved in the economic summit, even though they're good. I just won't see spending the money.
So you want to pencil on the 20th? So
Fine
that
with me.
makes that.
That's fine with me. It's the first day of summer.
Let's hope.
You'll have to wear flip flops or something.
And Our regularly scheduled next meeting will be May 1st then. And May 15th. When I confer with the treasurer on her schedule, I'll send an invite to the work session on the 29th. But, preferences, morning, afternoon?
Right now I'm wide open, so whatever works best for.
9 o'clock or later.
All right. All right, I think that covers meetings coming up. Regular court dates. General deliberation. I don't really have anything after this. I do. What was it? Oh, before the next, I was just talking with him on the phone this morning, before the next county court session, then on May 1st, I'm scheduling a meeting to talk to the financiers, so to speak, on the B Street extension project. So I will have an update on that project, at the next county court session.
Is that the kind of meeting where you might invite the building official to attend or not?
Well, this one, he's been at the previous ones, the planning and coordinating of the actual project itself. This one is, I'm more focused on the finances with Biz Oregon and the
Okay.
city of Burns and our agreements between us and them and whatnot. And again, you know, potentially an administrative cost that we might be able to get out of it for, because we're the recipient of the grant and we're gonna have to disperse the funds, and that takes man hours, and I would not like to just volunteer our time if possible. So I'll have something more on the next county court session on that project. Is the only thing I really, general deliberation wise to bring up.
I have a couple of questions on miscellaneous. Do you know if the My Way loan forgiveness ever was approved?
Did not.
It did not?
No.
Okay.
It wasn't, the ask was not really so much for a forgiveness of the loan, but for funds. Ask for funds that we could then pay for it,
Oh,
was what the ask was, and it
Okay.
didn't get picked up.
okay. And then tonight, it sounds like all three of us are planning to attend the Forest Service public meeting on the assessment related to the forest planning, and that's the fairgrounds at 5, is that correct?
5 to 8.
5 to 8 p.m.
I have had quite a few members of the public reach out. It's good to have some communication that way.
Yeah.
It's an ongoing process. And this is, like you stated, it's that initial phase, and so the mapping is very egregious right now. But you'll see in the next phase, you'll see all the things that are taken out due to the characteristics that don't qualify. And so, you know, it's keeping in line with the process and keeping up to speed with it as they come back with their next phase of changes to the map, which will indicate a lot to us. And a lot of things will be removed due to lack of wilderness characteristics that disqualify them.
What role, if any, does our NRAC have related to forest planning stuff?
Several of them had me print out the draft for them to read and review. One of them is in Nashville instead of being able to come to it tonight. But Mr. Reed did get a copy of it, as well as Bruce Rickman from the NRAC, and I sent an email to all of them with the draft to look at. And we're also looking for engagement with those two open positions. Hopefully with a strong emphasis on forest knowledge and understanding of that. I did reach out to some folks in the last week or two, trying to round up some people that might have some interest that would have that type of background, and waiting to hear back from them.
Thank you. That's all.
And I may have received it, but my inbox overflows. Could you forward a copy of that plan?
Oh,
The draft copy, please?
yeah. But
What's the assessment we're talking about?
it's the one I sent to you last, probably, I don't know, it's still. We'll get it to you.
Oh, thank
Because
you.
there was a February version and then there was a March version, and so make sure that when you look at it.
Just trying to do
the
a
March
catch
version.
up reading before the meeting tonight.
Yeah, it's a lengthy document. I have not even gotten
Yeah, I
all the
don't
way
plan on
through it. And this is what I kind of indicated to members of the public as well, is this is an instance where the BIC really, the Belize Intergovernmental Council will lend strength to Harney County as we look at reviewing these documents. Some of our partner counties do have actual natural resource staff that are paid county staff that have a lot of background in reviewing forest planning and that. And so I think, you know, really using our networking with some of those other counties like Wallowa and Baker that do have those kind of staff that are going to be able to have the deeper knowledge than what we currently have.
Good.
You know, that's, you know, to me, one of the bigger assets that the BIC does bring to us as a county is being able to work with those other counties and looking at their comments that they bring forward and being able to support their comments and, you know, see where those comments, you know, fit with Harney County as well. And so, well, that's something to keep in mind. You know, Harney County does not have that type of staff available, but we do have partnering counties that do. And so,
And even on the non-county official level, some of the people that have called me regarding, for instance, forest access for all and other types of things. You know, I've said, since we don't have the resources at the county, paid resources, people who can focus on this, and to the extent that the passion and focus of forest access for all, how deep is it in Harney County? And a couple of these people were ones at the meeting, et cetera, and they said, well, nobody, you know, they said, well, we care, so we came to the meeting kind of thing, but I said, well, if you participate with them, just see if you can be helpful to us on occasion and send us a summary of the key points and things like that, because they said it's not that we don't think it's extremely important, we do, but there's just not enough hours in the day for us to be really up on it and be able to focus a lot of our time on it, but we do want to help lead and represent our people in our county on this, so they're thinking on it.
well, I think a lot of what I've heard that group bring up will be more of the travel management side. And so once the forest planning is complete, there will be a completely separate process that is just travel management that will be engaged in, but it cannot start until the forest plan is actually completed. And so a lot of what they bring up are things that will actually really intersect in travel management. But, you know, they're looking for it within the forest plan, and it's a challenging conversation because access is not addressed within a forest plan. It's done within the travel management piece that has not been completed for the Blues. And so, you know, it's trying to just make sure that folks are aware of this having to be complete before some of those questions and conversations can fully take place.
They bring up some big anticipatory topics though, even at this early phase, so.
Quick go back as far as meetings coming up, just as a reminder, budget meetings tomorrow and Friday, 11:30 to 3:30. May 2nd, 11:30 also, I think it's only 2 hours though. And then May 2nd. Or May 30th, May 2nd, May 30th. So just for the record, and I don't have anything else.
May 2nd is also the Crane Play Day, FYI.
Oh, no.
I might not be able to run the bean bun toss now.
Would there be a better time if we decided to adjust?
I don't
We can
know.
talk about it tomorrow.
Yeah, I need to commit to in Clark, but I can run the bean bag toss now, so.
It's a fun day.
If anybody else would like to take that. It's only the 1 to 4 year olds, it's really fun.
Our May 2nd date is kind of just a catch-all for people who couldn't make it on these next 2 days. and to review all the other smaller funds or independent funds. You know, if you have to.
Well,
We'll have a
I
quorum
think the
still,
budget's a
so-
little more important at this moment. Just letting y'all know that that did fall on that.
So we're helping you out.
Anything further? For the good of the order?
Not a dangerous job.
Judge,
Oh, yes, sir.
I just wanted to thank the county court and specifically the emergency management manager for the county for putting on a very good courthouse security program last week in collaboration with our federal partners. It was an excellent program and I learned a lot and my staff really appreciated it. So thank you for allowing her the latitude to make that program possible.
No, well, thank you for participating.
and thank you for letting us know it was worthwhile.
Tried to be victim number 1, but I only got to be victim number 9. That was great. We really appreciated all the work that was put into that. So thank you.
Melinda, emergency management coordinator, Melinda Todd did a great job.
While you're in the room, would you mind giving the court a quick update? I've seen some headlines, for Measure 114, not being taken up by the upper courts, is that
No,
correct?
no,
Or-
it's still on appeal.
Okay.
The state, the defendants, the state was asking for the Court of Appeals to put in an immediate stay, which would have allowed them to implement Measure 114 as the appellate process was continuing. The appellate commissioner determined that there wasn't a clear winner from the record, and so it was best not to grant that stay, to keep Measure 114 at bay until a final decision by the Court of Appeals. They've expedited the process, which for many people would mean a few weeks, but it doesn't mean that. It means a few months of briefing by both sides, and then oral argument will be heard based upon the ruling of the court, probably sometime in December, January. And then it generally takes them 2 to 3 months to issue an opinion. So by this time next year, there may be a final decision from the Court of Appeals, but for now, the matter is, my judgment holds.
Okay, that's like the article indicated. I just wanted to get it from the horse's mouth. Thank you.
And I got the privilege of being on the county court of Grant County when the last time they were working through the forest plan process.
Yes,
It
you
had
were.
been through this comment period and it went on, the comment periods of course go on for a long time.
Right.
Just a reminder,
It's a
I'm sure you all know this, but just as a reminder, in the end, once they develop the forest plan, immediately before implementation, they allow community partners, their partners such as the county courts, to object to the forest plan. If you don't object, then you won't be heard any further. The plan will implement as it is without your objection. So if there are things that come to you through your community that are concerning enough to warrant further discussion after all the comment process, your objections will allow you to be in the room to discuss those finalization processes with the forest plan, with the Forest Service.
Yeah.
I'm sure you all know that. I just wanted,
Thank
one thing
you.
I did on the county court up there, so I
Yeah.
wanted to be sure that I mentioned that to you.
No, it's
Thank you.
very important to create standing in the process.
Correct. That's the better word. Good job.
Dominic.
Thank you.
Thank you.
Anything further? Not hearing anything. County court shall stand adjourned.
Yay.
It's always fun to watch democracy in action.
Yeah, you don't get to see that much, right?
Back end of democracy in action is what I see.